Never. Move this way. This is the final. Yeah. The judge has a with my application. Is that the one that you have? That one. Only a copy of the affidavit.
I have the affidavit here.
Okay. So I'll be making sure. So does this become the original? Because all the that's the affidavit goes with the original.
What I handed him was the one that the affidavit was attached to.
Oh.
But I didn't have the affidavit, so it was just a little confusion. Sorry about that.
So I wanted y'all to sign the motion before I actually signed.
Okay, so this is another copy. This is the original.
This is the original.
Yes.
Okay. All right, very good.
Came along for you this time. Because I'm sweet like that. I didn't even look.
All rise. Court will be in session with Honorable Judge Diane Tabasco.
Thank you very much. Everyone have a seat, please. change things a little bit here so I can see everybody. Thank you very much. And we're getting kind of a late start, but we're going to get started. In 1997C 103 and 1997C 104. I'm going to call both causes because I believe we'll be speaking of both here this morning and take judicial notice of our prior proceedings, everything that's happened in the case, and I need announcements, please.
Fifth grade, Your Honor, Lisa Tanner, Office of the Attorney General.
And with you, Ms. Tanner, is
Jenna Starnes, the Office of the Attorney General.
Daniel Brody, also with the Office of the Attorney General.
thank you very much. Can everyone hear all right?
Yes, ma'am.
Okay.
Mike Aaron, we here, Mr. Tiede, Jody Cole, co-counsel, Brian Garris, co-counsel.
Right.
And I wanted to announce that we're going to have another lawyer come in for the jury selection and beginning of the trial. Her name is Lisa Blue. She's from Dallas.
I know Ms. Blue.
Do you know Ms. Blue?
I know Ms.
But
Blue.
I don't have her motion for entry at this point, but I will.
Okay, that's fine.
We're ready.
If we could just kind of have a summary of where we are. I'm going to let you know that most of what I'm going to be doing is reviewing on an iPad for most of the things that you have filed instead of trying to do it on the computer. So it'll take me time to find it. If you have courtesy copies that I can use, that would be very helpful. This is pretrial. Let's go over the schedule just a minute for those who are here. This is pretrial in the murder case that has been designated as a case for trial. We have 1,000 jurors summoned as a panel to appear April 1 at the Henderson Civic Center. That day, the lawyers will not be talking to that panel. I'll be doing some just overall questioning, qualification. We'll pass out questionnaires. It'll be that kind of proceeding. The press is not allowed at that proceeding. This is just jurors. So, and there'll be no statements made by counsel other than their introductions. The next time that we will get together will be 175 to 200, and I need to talk about that with y'all, how many you need. That's what we can put in the courtroom in Henderson. So if we go to 200, those people will be summoned, and you'll need to be prepared to do your shuffle on Friday rather than Monday. You'll be shuffling Friday of those that are qualified and how they're seated. So you need to think about a shuffle then. When they show up on Monday morning, they will be in the order that they will be voir dire. So we'll get them seated for you. Everything will be ready to go, and then you'll start your voir dire after some just initial comments that I will make. And then Tuesday, we're reserving for some other pretrial, possibly, unless you tell me otherwise, unless these exhibits are properly numbered and everything's ready to go, then we'll have to use Tuesday to get all the exhibits in the record, finish up on any, pretrial that we need to do, and then at 10 o'clock on Wednesday, April 6th, we'll do opening statements. So that's the schedule, and we need to do as much pretrial here today. We need to get ready because I'm not sure that over in the Henderson Civic Center, which I'm going to actually go to and observe here in the next little bit, but I don't think we have private space over there so we can have a hearing outside the presence of the jury. So we've got to get this done today, if at all possible. What does the state of Texas have to review and
Your Honor, the only
present?
thing pending on the state's behalf is we still need to get the defendant's examination by our expert, Dr. Rambula, that has been ordered by the court, scheduled. There is a motion by the defense regarding that, but that is the only thing pending that we have.
What about your motions in limine?
Well, yes, Your Honor, we do have motions in limine. I stand corrected.
Okay. The defense?
On those two issues, Judge, with the motions in limine in a pretrial conference with everybody present, you were going to give us time to discuss that before.
I'll recess, let you look at it.
Yes.
But I really think a lot of what's on the state's motion can be agreed, and it is equally applicable to your situation, so
Okay.
we'll see.
And with regard to Dr. Rambula's meeting with Mr. Tiede, some of the problems with that had to do with a motion that we want you to hear and rule on is the dismissal of the theft indictment that you called this morning also, that's been on file for quite some time. That removes a lot of issues with regard to questions about theft that he can't testify to without an order from the court that they can't ask him, or that the theft is dismissed. So in relation to what Ms. Tanner said, that scheduling, which is the scheduling time is okay with us, but this huge issue about theft questions, if he's going to ask anything like that, can be resolved by you ruling on the motion for a speedy trial.
Okay.
If I could just address that. Their motion that they filed asking for clarification regarding your January 19th order for the defendant to submit to an examination by Dr. Rambula doesn't bring up the theft. I anticipated, though, that this argument might be coming, and I have spoken with Dr. Rambula and just advised him I wouldn't be surprised if the defendant wants to invoke some sort of Fifth Amendment privilege during that examination regarding the Fifth, and just be prepared for that. And he said if he did that, you know, his lawyer is certainly welcome to accompany him and be outside the room if he needs to consult with the lawyer. He can do that. And if he invokes his Fifth Amendment right in that interview, then Dr. Rambula doesn't plan on pressing the issue or asking him about anything that he invokes his Fifth Amendment regarding. And so he's prepared to deal with that if that comes up during that examination. So we anticipated that that might be something that was unsaid in this motion.
That's well taken. Although I haven't talked to Dr. Rambula.
I don't see that as an insurmountable problem. It looks like it can be dealt with.
Well, it says if Mr. Tiede doesn't cooperate with Dr. Rambula, then we can't put on any evidence with regard to psychiatric. So the question is, my lawyer said I can't answer these questions. And he says didn't cooperate, we lose everything. So we're worried about that. And one way to prevent all that is to have recorded the interview between Dr. Rambula and Mr. Tiede. It's just,
Well, if we're going to go ahead and address your motion to clarify, let's just go ahead and address it.
Okay.
I've read your motion. I understand what the state's response is. I kind of got from what you all filed that you didn't have a strong objection to the recording if I would review it in camera. But how long an interview are we talking about here?
I think it just depends on sort of the, how it flows. First of all, I just want to make clear, I don't believe that Ms. Tanner or I would consider that not cooperating with the interview if he just invoked his Fifth Amendment regarding any kind of theft or those kind of extraneous theft issues. We wouldn't consider that, not following the spirit of your order about cooperating with the examination. It might be, I do know he's done them, they could be 2 hours, 3 hours, as much as 4 hours maybe. I really don't know. It's sort of it just sort of depends on how it flows. I didn't really address how long he anticipates it to be, just based on my knowledge of how long these usually take. They could be a couple hours, they could be 4 or 5. I have seen them as long as 9. Those usually involve testing by a psychologist, though, and not a psychiatrist. So he won't be doing any kind of psychological testing. So that won't tag onto it, I guess.
So that's your best estimate. Yeah.
and I think you're right, Judge. We may resolve that one issue about uncooperativeness by agreement with attorneys that if he, through my advice, takes Fifth Amendment on questions about theft, that's not going to be considered being non-cooperative. Okay.
That would be against the spirit of my order. That's correct. Okay. the report goes to me, couldn't a report and a tape come along in the same, that's not a problem?
Right.
Okay.
May I ask a question about that, Judge?
You may.
My understanding is from discussions we had both in, thank you, chambers and maybe in the courtroom, that the state will not look at that report. Okay, so it comes from Dr. Rambula to you.
Directly to me.
State to you, right?
Right. So would the tape.
Okay, I just want to make sure we keep that bridge.
Okay, so to the extent that you have requested that the interview be audioed, I will go along with that. I do need an absolute commitment on when this is going to happen and how it's going to happen. So if you need a minute to talk to your client, but we need to get this on the record when it's going to happen, because we're running out of days here.
I am told, and I agree, that the 22nd is okay with Mr. Tiede and also Jody Cole and Brian Garrison.
Okay. Then March 22nd, if you'll notify Dr. Rambula of that date so that he can be ready for this to
Send him a
happen.
text to see what time he would like him to be
Okay,
there.
that's a good idea. Okay. So could you get me an order about this, Mr. DeGuerin? And some of these orders, when we separate from here, y'all forget about the orders you're supposed to give me, and I've got orders floating around. I need an order. This probably I need to redirect this to Mr. Garris, but I need an order by in the morning so that sometime before noon, I need an order I can sign on the motion to clarify.
Okay. Well, one further thing about that issue.
Okay.
When I read the state's, maybe their emails, maybe their motions about interview with Dr. Rambula, it didn't seem like it was insistent that it happened down in San Antonio when everybody else is in Austin. So I would suggest that it be done in Austin rather than in San Antonio.
Your Honor, it's so unusual that Dr. Rambula is interviewing someone convicted of murder who's out on bond. And just for security issues, he prefers to do it at his own office and not come to some strange location. And also just because he has everything that he would need to do his interview there at his office. There's really no other option in Austin. He doesn't, of course, for obvious reasons, want to come to a defense attorney's office. We don't want to have the defendant in our office.
Enough said, Judge.
Okay, whatever. Let's just do it in San Antonio. Okay. But we need a proper order. And on the order, the change of venue order that we're still looking for, did you find it?
I did, Your Honor. I emailed it to my investigator and asked her to print it out for me.
Okay, and it does have a date, it's signed and everything?
Well, it's just a blank copy of
Okay,
the order.
then I will
don't-
re-enter it, noting the October 22nd change of venue. Okay, what else?
Sorry. We covered the base about the state doesn't get the report or the interview.
Right.
I want to make sure that also that they don't get to hear from Dr. Rambula what Mr. Tiede tells him until it becomes a Fifth Amendment waiver.
And Your Honor, I have dealt, as has Ms. Starnes, with doctors in this situation before. And I want to make clear that Dr. Rambula understands, as do we, that we don't get to talk to him about any conversations he had with the defendant, any conclusions he drew, anything as it relates to the examination. And he knows that, we know that, and we intend to honor that. Now, one thing I do want to
You're
say
officers
is-
of the court, and I think
Absolutely.
that's,
But as a point of clarification, I've had it come up before where the defense has said, oh, well, you shouldn't even be allowed to talk to him. Because obviously there are other things separate and apart from his examination that would be relevant, that we may want to talk with him about. And we understand the parameters, he understands the parameters. So I want to make sure that we're all clear. That doesn't mean, we can't speak to him about other things. So as long as we're clear on that, but we fully intend to honor that.
But not about psychiatric things.
Well, general psychiatric things, but nothing that has to do with his examination of the defendant. I mean, not just,
Can we
not
put
just
that,
basketball.
when we do this order, we'll just kind of,
Just put a little sentence in there about something like that, yeah. But I do need it by noon tomorrow.
okay.
Okay, you have a motion for continuance on file, Mr. DeGuerin. Perhaps we should have
Okay.
crossed that bridge first instead of second, but what is your motion? And I've just gotten it, and I haven't even read it.
Okay. Well, let me give you a second to read it, so I'm not talking while you're reading.
Okay,
You have a copy on the book?
make sure that I do. Actually, no, I think you took all of them.
Well, here's one.
Oh, here, Ms. Johnson has one, thank you. Okay, I've read the motion. I understand it's about the 250 alleged incidents. I've been over these because it was in the extraneous offense notice, so I mean, I know about all these. I'm very familiar with them. But go ahead if you'd like to.
Well, the exhibit is the 250, where they listed specific transactions of theft.
Right.
I've been practicing law, Your Honor, for almost 50 years. Had many, many trials. So when we got this information on Monday, I believe it was, I sat down and said, to be effective, we would have to know about these 250 transactions, which their expert say, by looking at these transactions, he has an opinion. Now, Exhibit B gives us the notice of on or about different dates. So I sat down, in fact, I had an office meeting with all the lawyers in my office, and I said, how long would it take to become effective in knowing about these transactions, asking about them, looking at them, getting a copy of the checks, asking different people what the checks came for and where they were spent, and was there reimbursement, was it an investment or not? And I came to the conclusion, Your Honor, that it would just be impossible for me to tell the court that I could be an effective lawyer on these issues during the trial with so little time left to do it. So that's fine, the motion for continuance. If there is going to be a continuance, I better ask for it now rather than on Friday before the trial. And I can see now that this is going to be a situation where whatever happens after trial, without sufficient time to prepare for these things, it's an ineffective assistance claim. And I'm not sure if we want to go through the whole process if that's going to be a legitimate issue complaining about me when I'm admitting right now I don't see how I could possibly be ready. So I had heard, and I've talked to Ms. Tanner about this and Ms. Starnes about this. They say, you've had this stuff in a secured share drive, something like that, but since October or something like that. I know that argument, and I understand what they mean. It's all out there. They're experts that pulled out the actual checks, but we don't have them. Their experts have already gone through it. We don't have that. They have a team of people working for them, and they're paid by tax money. We don't. We're raising money through a fundraiser that just barely got, well, anyway, to make a long story short, we don't have it.
Okay.
And we need experts. We need time to prepare. Now, I'm not doing this. I'm not raising this motion, Judge, to make it terribly uncomfortable. If you were to grant my motion, to make it uncomfortable, to make those calls that I know you have made to Henderson over and over again, arranging for the trial as it's presently set. And I think that the biggest argument against my motion is, how am I going to tell all those people we're going to probably have it another time? So I understand up front that the state could argue that somewhere amongst the, I forget the amount, 450,000 documents they gave us, all these things exist, and you need to get to work to go look at them, and you can find them, and we'll give you some hints. I don't think we can do that between now and April 1st. Just don't think we can do it. So, and I understand that they can argue and have argued to me and have, maybe even to the court that, look, the material's there, you just need to hire some people to go through it like we did, and you'll be ready. I understand that too. And I'm sure these things are found, can be found eventually, not in time for trial.
Ms. Tanner?
Your Honor, if I may respond. The defense has had the documents set forth in the notice that was provided on Monday since September of last year. They've had them both in the form that we received them, in the boxes of evidence collected from the respective homes. They have also had them in a separate disc that was organized in such a way that all the financials were put into one place. So
What disc was this?
Disc 2.
Disc 2.
That is correct. So each box, the financials that were in each respective box collected are given to them within the box, as well as on disc 2 in one organized fashion. They've had that since September. Mr. DeGuerin came on board October 27th, and I remember we had a trial setting in January, and the court said, you coming on board isn't going to derail this January trial. Well, it did.
It did.
It did. And we have been bending over backwards to give them everything that we have so they can prepare. We gave them notice on December 1st of the overall totality, the 404B and 3707 notice of what all these transactions meant. We gave them that notice December 1st. This notice that we gave on Monday kind of falls into the no good deed goes unpunished category. They filed a motion before the court asking for a gatekeeping hearing, and in it they included something regarding the dates. So we thought, well, okay, here we provided the court with the research that says that we are not required to give identical dates in situations such as this. However, in an abundance of caution to make sure they were absolutely noticed, we gave them this, what is referred to as a MOF notice of transactions. It is not a notice of new thefts or new allegations. It is the basis under which our expert has formed his conclusions. We have given them our expert's report. They've had that since March 4th. And, Your Honor, they have 2 forensic accountants on board already. And I know that because they brought them to our office on February 10th. And so they have 2 forensic accountants who are working on this case. I obviously don't know what they're doing, but I know that, and I don't know how long they've been on board, but I know they've been on board since at least February 2nd.
Is that the case, Mr. DeGuerin?
Yes, I was going to respond.
Oh, okay. Okay. I was curious.
And so, Your Honor, we are doing everything that far more than the law requires to make sure that they have notice of what we intend to prove at this case. And because of that, we very much object to this motion. Our witnesses are subpoenaed, we're ready, and we're now 8 months past when we were originally supposed to go to trial in this case, and so therefore we object to this motion.
May I respond?
Sure.
First of all, the entire argument by Ms. Tanner was, we've done nothing wrong. We, the state, have done nothing wrong. I hope I made it clear. I'm not objecting to the notice that was given to us. I am objecting to the timeliness of the notice. All of a sudden, it's huge coming Monday, and we have trial to prepare for. That's what I'm objecting. I'm not angry with Ms. Tanner or Ms. Starnes or the Attorney General's office for going to the effort of giving us the notice they've given us. I mean, good Lord, someone did a lot of work to pull out every one of those transactions and print it up and send it to us. I appreciate that. And that's the way it should be done. Now I need time to do something with it. Do we have document examiners? Yes. We hired, we begged for them to do, just give us a glimpse of what's going on here. And I'm not going to go into the minimal amount of money we were able to raise to get them started. We have a hearing, ex parte hearing in a little while about those matters. But yes, we do have highly talented, very expensive document examiners who are willing to help us, but they need to be paid. And they did go with Jody Cole to the Attorney General's office one day. May Ms. Cole make a few statements here, Judge?
That's fine.
Your Honor, I enjoy doing discovery. Oddly enough, it's like a puzzle figuring it out. But it is disingenuous to say that we have had everything when on the 14th we got 39 financially related documents provided to us for the first time. And this has been coming all last week. And I have to tell you, it is hard to go through that discovery when I have a 495-page PDF that I cannot even send to my forensic accountant to look at. And it is all sorts of documents combined together, and they're non-searchable PDFs. And I'm doing, my assistant, Donnie, is working so hard to get this material organized, and then I'm working hard to make sure the forensic accountants have the material that they need. But it is impossible to claim that we have had everything that we've needed in a searchable form since, what was it, October?
September.
That's not true. They have been sending discovery all this time up to the 14th.
And we're not complaining
Your
about
Honor.
them sending us discovery. We appreciate that. Now, I mean, don't get it wrong.
It's the volume and
It's
the
the volume.
managing of that data. Let me ask a question.
Yes.
Okay, if in that disk,
I'll let Mr. Brody speak to this.
okay, thank you.
So if you were to look at the discovery index itself, it's labeled by.
And we're talking about Exhibit B, correct?
No, Your Honor, that's the list of transactions. Attached to our response to their motion for discovery, we have included the discovery index. And that's what we're referring to. And that references the itemization of box 2 as well as all the other boxes.
You may not have that.
I don't think I've got it.
Here.
Do you have an extra?
Here it is. I think it's looking at the list.
Oh, yeah. Okay, thank you.
That's the list that you.
So if you're looking at the discovery disk, those are the actual PDF files listed that have been turned over to defense. And it is descriptive enough to tell you, the accounts, the account numbers, and various names of what the documents are that are contained within the various boxes. There's 30 total boxes. There's also, towards the back end, it goes through discovery disks, and that's going to tell you more things that just tell you the account number, the bank name. It's all searchable. Unfortunately, that's how the files were given to us. I wish I could have had this organized in a way better fashion, but we got 29 boxes with accounts everywhere.
And just so we're all clear, these are copies of bank statements and airline and credit cards and investment reports and I guess some royalty statements from oil companies, all kinds of stuff.
Non-financial.
Right.
All sorts
And
of
let me say, Judge, for the record too, regarding the discovery that Ms. Cole's referencing from March 14th, she's correct. There was some new discovery. It is a box of material, as I shared with them in an email, that got stuffed behind some other boxes in the sheriff's office, and they called us last Wednesday and told us they had it. It does not have any financials that are relevant to this case in it. It has some ancient old financials of the Nugent family. It has travel itineraries, things like that. Nevertheless, we've scanned that and given that all to them. Our legal assistant started Thursday
Okay, then let me ask you this. Do you plan on any of that being relevant and coming into this trial at any point?
I don't see how it would, Your Honor, but the purpose.
Is it exculpatory or mitigating?
No, Your Honor, not in my opinion. The materials that are referenced in the notice they're complaining about are in the boxes, which were provided in September, and on Disc 2, which was provided October 22nd of 2015. So whatever the new evidence is that we've given them is not the basis for all of these transactions that have been talked about.
So we're talking apples and oranges here.
I believe so, Your Honor. I
Okay,
believe so.
Ms. Cole has something to say, I believe.
That is not true, Your Honor. The documents that we just got last week are highly relevant and exculpatory. They are not relevant if you expect someone...
Describe them to me.
They're trust documents that show a history of contention between Marge Nugent and her children, and apparently she was removing corpus from this marital deduction trust and labeling an investment in order to hide this money, and this is the money that is being alleged to have been stolen by Bernie. And what I suspect is she was using Bernie to launder this money she was stealing
We
from
need
her
to refer
grandchildren.
to him as Mr. Tiede.
Oh, Mr. Tiede, I'm sorry, Your Honor.
Okay.
I apologize.
From now on, forevermore, he is to be known as Mr. Tiede.
Yes, Your Honor,
Okay.
sorry about that. I believe that she was abusing Mr. Tiede by forcing him to stay with her, by getting him on the hook with a lot of financial gifts and investments in his businesses. And I believe Mr. Tiede did not know that the money that she was lavishing on him did not come from her estate, but from this trust corpus of this marital deduction trust. And we have just gotten important information about that, including evidence that shows the litigation of her grandchildren alleging that she was stealing the corpus.
Was there a lawsuit that was actively
Yes, Your Honor.
going on?
And these ancient documents they're talking about, we just got that. And when I'm going through this discovery, I came across that I had been on this case for 4 years. There is a concurrent will contest that was involved with the original plea negotiations. They're highly relevant and exculpatory because some of the evidence they are so excited about introducing to Bernie was a product
I
of
thought he
these
was going to be
plea
Mr.
agreements.
Tiede.
Oh, Mr. Tiede. I will slow down and be
Please.
conscientious. That document was falsified, I believe, by the estate attorney of this will contest. All these years from any of the legal filings of this will contest that I've seen, allegations were made that this 1987 will of Mrs. Nugent that excluded her son from taking the estate was destroyed or lost. That's what I've been told. I found that in this discovery last week. And that's serious.
Not our discovery, the discovery provided.
I understand.
And I can tell you, Your Honor, I'm diligently trying to organize and go through that kind of stuff, but I am finding things, I cannot believe my eyes what I'm seeing and how to cope with that. We do need time to figure that out, but this is highly relevant. This is exculpatory evidence, especially when they're trying to introduce any kind of financial motive attributed to Mr. Tiede that would have contributed to the snapping that occurred when this death happened. And that is vital, Your Honor.
Have a response to that, Ms. Taylor?
Your Honor, this is all very interesting. However, what I am telling the court, and I stand by, is their complaint is about the notice that we've given them and the financial transactions upon which we are relying. That information they have had for 6-7 months now. And as I said, all of that is interesting, but it doesn't have anything to do with what the basis of this continuance is that they are asking for is about. And secondly, regarding all this stuff about the trust that she's talking about, she's had the documents of Longview Bank that set all the trust stuff out for months as well. This is in addition to that, but the point is that this corpus of this trust, that's no surprise. They have the documents just in a different format and have had those for months. So we completely understand that box, and we'll be happy to let the court look at box 30 to see what it is. It's old family stuff that I believe is not relevant. I believe will be subject to our motions in limine. And that's apples
Well,
and
that was my
oranges.
next point. I think
Yeah.
I remembered seeing something
Yeah.
about all of this family stuff is not, you are requesting that it not be mentioned during the
We
trial.
believe it should be subject to a motion in limine, yes, Your Honor.
Okay.
And so I believe, as the court said better than I could, I believe this is apples and oranges.
Well, I know it's a lot of material. I understand it's a lot of material. From the very beginning, when we were talking about this, everybody knew this was a lot of discovery to go through. You guys have done a good job putting this together, reviewing it. I gave you a continuance to do exactly that. If you'll remember, when we were here before, I specifically said this was to get this discovery question resolved. Now, anything in this last box, the only thing I'm hearing here that's kind of concern is this last box of information. You have 4 lawyers. You're going to ask me, I'm assuming, for some additional help regarding forensic experts. We'll cross that bridge when we come to it. They have overshared, perhaps, on the documents that they had to provide and the organization of those documents, and specifically enumerating exactly what they're talking about in these 250 transactions. I don't see any reason here to grant a continuance for a box that arrived last Wednesday. Yes?
Your Honor, I need to also mention that they supplied us with reports that they have had for months last week. And I had looked at a recent report that was supplied to us, and it said...
A report of what?
Of interviewing of a witness. There are things like, we find out that there possibly was this third party involved in a homemade sex tape that was used to coerce Mr. Tiede. We just found that out, I guess, from this dated... It looks like there was a November 26th, 15th interview, and then a January 26th.
We've been talking about 3 sex tapes for at least 6 months.
We
I
never
don't
knew
know.
there was a third party, Your Honor.
We told you. We talked about
Not
it
in a report.
months ago.
And I did not know that someone from the sheriff's department was burning evidence related to this case. I didn't know that till recently. And that just came from them, Your Honor. It's not just financial. These are Brady issues. That's serious.
Understand, and you'll have a chance to talk about that at a later time, perhaps, in another pleading. But I've never had a case where there wasn't some late discovery. It just kind of happens. If it's Brady material, exculpatory, mitigating, this is a mitigation case, is what this is. This is a punishment trial talking about mitigation. So, if and when that evidence were to be presented by the state, I'm going to allow you to make an objection to have it excluded if it's such that, you haven't had proper notice of it. But at this point, we are not continuing this case. It's going ahead on April 1st. So your motion to continue the case is denied. Now, there's some other issues. I believe from the defense that you have some more things that you'd like for me to enter today.
I guess our motion for a gatekeeping
Right.
hearing, that's granted. I guess we're going to have a gate.
Well, what's your response to it?
Judge, as I've put in my written response, we have no objection to having a gatekeeping hearing, but I want to make sure that we're clear on the parameters of what that is. If counsel for the defense is asking for a proffer from us, which is my understanding of the law, is what the law requires, then we have absolutely no objection to that. If counsel for the defense is asking to have a dry run first and put the witnesses on the stand outside the presence of the jury to prove it up beyond a reasonable doubt to the court beforehand, we do object to that because the case law says that that's province of the jury. not the court. The purpose of the gatekeeping hearing is for the court to determine whether the incidents the state seeks to introduce are relevant and whether it appears that the state can prove them. And the case law says that that can be done either by a written or an oral proffer by the state to the court. We have no objection to that. So I don't know exactly what you're asking for, but if that's what you're asking for, then we have no problem with it.
Mr. Tigran?
If the oral or written proffer is sufficient to this court's appreciation, we want that, of course. There may be situations that we may need to hear testimony, so I can't.
It may come up. I mean, if there is a reasonable need for that to occur during the trial, we'll do it. But, you know, taking witnesses on voir dire outside the presence of the jury is cumbersome, as you know. But if we need to do it, we'll do it. A proffer is normally easily enough done without having to do that. So I'm going to allow you that latitude. If you need it, we'll do it.
Okay.
I don't see a problem, but it would have to be exceptional. It would have to be something kind of outside the norm. I need an order on the gatekeeping, so it's granted with that one stipulation that the court will make any rulings regarding witness voir dire. I need an order on the motion to continue also from Ms. Tanner. That's your order, Ms. Tanner, denying the motion to continue.
Oh, okay, I can do that.
Okay. Okay, now, that is granted. What else?
Ron, the motion to continue does have a blank order on the back.
Oh, okay.
You can just scratch
The court can do that.
I can do that one. Did you hand me your original?
I think your clerk did.
Just about for clarification, if an oral proffer is sufficient for the court, I mean, the case law.
Right, an oral proffer is going to be fine,
Thank you.
except in exceptional circumstances that we'll address during trial.
No problem, thank you.
Just a moment, I'm going to do this order so we have it already done. I'm going to give it to Ms. Johnson to be file marked. Okay, now,
You had asked, I thought I was standing before you asked me a question, but I do have a comment to make about the trust stuff that we were learning in the trust and the probate. Yes, Your Honor, to answer your question, there has been lawsuits filed. There was a fight between the sisters of Ms. Nugent and the children of the child of Ms. Nugent, and they fought over alleged thefts by Mr. Nugent Jr. from the trust, etc. Those matters happened here in Carthage. It was Carthage, wasn't it?
Yes, and
Tyler and Carthage. But the main court was in Carthage, wasn't it?
Great County, too.
Yeah, I don't want to confuse things.
Gregg
There is a
County,
main
Panola
court.
County, and Smith County.
Yes, and
Okay.
there was an order entered, and then everything was sealed. And the Mr. Noble that was involved in the case is the one that prepared this motion to stop the 91 will signed by Mr. Tiede. He wasn't representing Mr. Tiede, but he prepared it and signed by Mr. Tiede, and that was filed in the probate court. And we know that. Later, he filed an affidavit saying that motion is not, and that affidavit is not real. The point is this: we can't get the documents and the papers from the court because they're sealed. I know we can if you find that we believe those are relevant to our preparation for trial. So with your permission, I will have that motion to the court to order those probate matters having to do with the Nugent, Rhodes family, and Mr. Tiede to be released to us, or at least copies of them so we can know what to do with them. Mr. Noble, who was handling the Mr. Nugent's side of that case, says he's no longer has, no, okay. Anyway, I'm getting the names. Mr. Sherman, who was handling part of that case, says he's destroyed all of his files. So we have to go to the probate court to get those, what I believe to be very relevant documents, and how they divided up the estate and somehow ignored the 1987 will and went back to a will in 70-something that awarded things to Mr. Nugent Jr. So my point is, Judge, along that same line, we'll get a motion to you, short motion, for you to consider about entering an order that those records for that particular case will have it outlined should be released to Mr. Tiede's attorneys.
Objection?
Well, Your Honor, I've seen the motion.
haven't
However,
filed it.
right. However, it strikes me that this is all, again, rather interesting but not relevant to the proceedings that we are here for. Mr. Noble, the counsel talks about, is actually a lawyer for the estate. He is not a lawyer for Mr. Nugent, nor has he ever been. Mr. Sherman, same thing, was a lawyer for Mrs. Nugent's sisters in a will contest that occurred over a year, 2 years after the murder for which we're here, over a year after his trial. And so, again, while interesting, I suspect we're going to object under relevance, that this is far afield of what we are here for. But until I see the motion, I can't say for sure, but I'm pretty sure we're going to say that this is utterly not relevant to the proceedings that we're here for.
If they have those papers and they've been doing their investigation, it's not among the 60,000, 70,000 documents you provided to us. If you have them,
We've given you what we have.
okay.
So
they don't
you don't have them either?
I don't believe we have them.
My question is, I can sign all the orders in the world, but, the court that has them under seal does not have to open them. I'll look at your motion. I think, let's just look at what you're going to present, and we may need to get on a conference call or something and talk about the motion and logistics and such as that, but.
With Ms. Tanner, you're talking?
Right.
Okay.
And discuss it between now and then. I'll be happy to look at it, see what it is that you're requesting. I don't think anybody has those documents but the lawyers and parties.
And
It's the only place you're going to get them.
the one strikeout I had, I got the name wrong, was when I called the lawyer that would have had them, said, I destroyed all those. So, end of story. But what's sealed is how they divided up the estate. I mean, that's what I'm assuming.
Well, let's see if we can get it.
Okay.
Okay?
Okay, Your Honor, well, I know you have several things you want to ask, but another thing I think we should bring up now, and I don't think there's an objection by the prosecutor pro tem, and that is there was some grand jury doings of people called before the grand jury, both federal and state. And we have been given portions of one or two testimony, but not the
Right.
testimony. So we'd be asking the court to order the state, or request the state to file a motion to release the secrecy of the grand jury proceedings so we can have that to prepare for trial.
Judge, that's actually a very interesting area. We have provided the defense with grand jury testimony that we have. That would be some state grand jury testimony of one witness. and some redacted federal grand jury testimony of several other witnesses as it pertained to the murder case and not the financial investigation, and the grand jury testimony of the IRS investigator David Carter back then. They've received those items. We have noticed, however, or let me back up. We are aware, and we have shared with the defense counsel, that the federal government did do an extensive financial investigation back shortly after the defendant's arrest that Mr. Carter was the lead investigator on. There was a fair amount of grand jury testimony. There were reports written.
Was this out of the U.S. Attorney's Office?
Yes, Your Honor. And that was all done. Ultimately, after the defendant's conviction and sentence in this case, the federal government did not file charges. They relied upon the state conviction and sentence. And that case ended. The federal government has a 10-year retention policy, and apparently that is non-negotiable. And the federal government destroyed their entire file after the 10 years passed. That was long before all of this came back up. And so when we got involved, we sought out the federal government's file and learned that it existed no more.
Okay.
So, that being said, we have also, back up, we have contacted the U.S. Attorney's Office, and their file also fell under that same retention policy, and it has been destroyed. The U.S. Attorney that was involved in the case was a Mr. Wes Rivers, who unfortunately passed in 2007, and so he is not available either. We have received everything that the District Attorney of Panola County has, and it does not include that Mr. Carter's investigation. However, we have reviewed the record of the trial in this case, and in the trial, on February 8th of 1999...
Do you have a line-page reference in the transcript?
I do, Your Honor. It's Volume 8, starting on page 921 of the record. There is a discussion between defense counsel and trial counsel, at which the prosecutor has indicated that he tendered grand jury testimony of several witnesses, as well as the transcripts of the grand jury testimony of several witnesses, as well as Agent Carter's reports, his handwritten notes, basically the federal investigation. So, and that's acknowledged by Mr. Holmes, that is all turned over to him on February 8th of 1999. And that's all in the record. Point being, Your Honor, they have it and we don't. I believe from our discussions over the past year or whatever it's been, that Mr. Holmes turned over his entire file to Ms. Cole when all of this came out. And I believe Ms. Cole shared that with us. I don't know how I know it, I just know it. So what that means is that they already have it and we don't. And actually, we, having come across that, are in the process of looking at the law to see if we can file a motion to ask for it, since it's our discovery that was given to them and we don't have access to it anymore. So point being, all of that is to say that that which does exist, they have either from us giving it to them, if we have it, or they've had it since 1999.
Okay.
Yes.
Your Honor, I wasn't fully clear when I asked about the grand jury testimony. I thought we had discussed that. At that time, I believe you were trying to figure out a way to get the grand jury testimony to us.
Well, to be candid, we found that in the record on the way up here yesterday.
Ooh, see this late discovery, Judge.
Well,
and
no,
by the
Oh,
way,
man, we're going to get back on that horse.
in the spirit of
we have tried to see.
appreciation.
Well, the point is
Ms. Tanner did tell me she thought there were 3 people involved a while ago.
Right.
We know of 2 and of somebody else, but she didn't know the name. So we have had that conversation.
Yeah.
Okay.
Okay. Wait, let's.
Let us revisit the grand jury thing.
Okay.
And I will talk with Scrappy again.
He's going to remember what that grand jury testimony was, I would imagine.
Yeah.
Where it might be.
Yes, and I don't know whether that would be something harmful to us or helpful to us. I just don't know. I'm just asking for it because I always do preparing for trial.
Okay. Okay, good. Now, what I have left here is motions to suppress and still the motions in limine. You want to talk about your motions to suppress? Because we got to get that done here today.
Okay. I believe we need a hearing on the motions to suppress. There's, one is to suppress the statement that was coerced with the tapes. That was not raised like that at the trial before. It was raised by Scrappy that he had asked for a lawyer, that when he asked for a lawyer, they quit asking questions. By the way, they arrested him at his house. Read in his rights coming down to the police station. Got to the police station, they wanted to ask him questions about Ms. Nugent. He said, I think I need a lawyer. They quit asking questions. Put him in a jail cell or another room. Jail cell or room? Jail cell. Later, they go to his house and search his home. Without a warrant, I don't believe. When they come back from searching the home, Mr. Tiede wants to know what they found at the home, words to that effect. They took that as an effort by Mr. Tiede to restart the interrogation process without a lawyer. Mr. Holmes contested that. There was a hearing on that. They had tape recorders, a couple of doors down, but they didn't use them during the statement. And make a long story short, there was a hearing on that in the trial before. It was denied by the judge at the time. And there was a motion, or at least discussion and hearing about whether or not the stuff that was seized at the airport, his home, Ms. Nugent's home without a warrant, whether those were suppressible or not. We think we need to revisit that. And we have new evidence and new understanding now than what was had back then. So I think we need a hearing. I know that we're working on a time restraint, and we're going to have to do it. You're going to pick a time or before the trial or something, before we make opening statements or something, so we'll know what restrictions we have. But I do believe we need to address those like real issues and dignify them just like starting over.
Mr.
Your Honor, first of all, I think we need to separate these things out because there's two motions here. There's a motion to suppress statements and a motion to suppress physical evidence. As it relates to both, however, there was a full-blown suppression hearing prior to the first trial. The defendant testified, all of the relevant officers testified, and the trial court denied it, as to both the search and as it relates to the defendant's confession. At trial, they re-alleged the motion to suppress statements. The trial court denied it again, and then that went up on appeal as a point of error on appeal. The Tyler Court of Appeals ruled against the defendant and said that the statement was admissible. The defendant filed a petition for discretionary review, and that was refused by the Court of Criminal Appeals. And so it is our position that the issue of the admissibility of the statement under the law of the case is done. The law of the case clearly talks about how if a appellate court has made a final decision on the case, on the merits, then the law of the case dictates that it's done. It does not need to be relitigated. And just because they say, oh, well, now we have new evidence, well, you now have new arguments, doesn't mean that the law of the case shouldn't govern. And so that's our position as it relates to the suppression of the statement. As it relates to the suppression of the physical evidence, I recognize that we're not on as solid of ground because the law of the case does not so clearly govern it. But the search of the defendant's home was fully litigated at trial. There was an oral consent to search, and subsequent to that, there was a written consent to search that was both signed by the defendant and in his testimony confirmed as having been signed by the defendant. And that was all litigated. Now, at trial, the state did not put on any evidence that came from the defendant's residence, so that issue didn't go up any further. It ended at the motion to suppress. So I understand that the law of the case may not necessarily govern to the same degree as it does with the suppression of the statements, but it just seems that that issue has been litigated already extensively. Regarding the search of Mrs. Nugent's home, that issue wasn't litigated already, but the simple fact is it's her home. He didn't have standing to complain about that. He didn't live in it. So that seems like kind of simple. And regarding Carthage Aviation, first of all, we don't anticipate introducing anything from Carthage Aviation anyway, and that was all done via the federal investigation. So for purposes of the motion to suppress evidence, I still believe it is well within this court's discretion to say, this has already been fully litigated. Clearly, the motion to suppress the statements, it has been fully litigated. And based on those arguments that I've made, I don't believe that this is appropriate for us to have just a big do-over as it relates to the suppression, and so we would object to having a hearing.
Okay. Anything else, Mr. Gary? Whoever's going to, Brian, you're going to address it.
Yes, Judge. I think that what, and I didn't, when I wrote the motion to suppress statements, I didn't artfully put this. It just this issue came apparent to me yesterday. I think with the motion to suppress statements, there's actually going to be a Fourth Amendment issue with respect to the seizure of Mr. Tiede to begin with that led to those statements even having happened at all. The way I wrote it in the motion to suppress statements was as a Fifth Amendment issue. I think there's actually going to be a Fourth Amendment issue as it relates, and that has not been litigated to this point, or has not been previously litigated.
Remember, Judge, from the trial that you've read, family members went to the house with a deputy or some other people, and they took some hinges off and went in the house and looked around for Ms. Nugent. They found her in the freeze. After that, they go to Mr. Tiede's house and arrest him and take him to jail. So the Fourth Amendment issue is under 1401, 2, and 3, there was no statutory right for them to arrest him at that time, and no probable cause presented to the judge. And so the issue is...
Well, there was an arrest warrant.
Yeah, I'm sorry, but that's inaccurate.
There was an arrest warrant.
Well, I stand corrected. I didn't know there was an arrest warrant.
Yeah.
Can you produce it, Ms. Tanner?
I have it. I've got it out in the car at the hotel.
Well, that's okay.
Yeah,
I'll take your word for it. I'll take your word
and I can clarify. And this all came out of the motion to suppress hearing. They went to his house. They said, "Would you come down and talk with us?" He said yes. He rode in the front of the car, no handcuffs, not under arrest. He was Mirandized, but that's just good police conduct. He was Mirandized. He rode in the front of the car. He was not handcuffed. He sat in the office with them. He talked with them. He was not under arrest. They were waiting on the arrest warrant. The arrest warrant was then served on him, and he was placed under arrest. And that was after the time that he invoked.
Okay, so my memory was correct. There was no arrest warrant at the time he was taken to jail.
There was an arrest warrant at the time he was taken to jail. There was not an arrest warrant. It was being drafted at the time that he rode to the sheriff's office with the officers in the front of the car and was at the sheriff's office, but not in jail and not under arrest.
So not in custody.
And not in custody.
No, he could not. He was not free to leave.
Well, that's
and he was
a fact
Mirandized. He was told to sit in a
and that's
office.
just it's all been already litigated. That's the whole point. That's
Okay.
already litigated.
So here's the deal.
I tell you.
I think it needs to be litigated again. At least
I understand. If you want to amend the motion that you have filed, you'll need to do it very quickly. I'll let Ms. Tanner respond if she likes very quickly, like 3 days. And then I'll enter a ruling on both of the motions to suppress. I'm assuming you're only talking about the statements as to any Fourth Amendment issues. Is that correct? Not on the physical evidence.
Well, I think, Judge, our other motion to suppress evidence, or the one that we've already filed, relates to physical evidence.
Okay, so it would be as to both motions.
Yes, Judge.
Okay. Then amend both motions. Within 3 days, she'll have 3 days to respond. I'll have a ruling for you.
Yes, sir.
And then I want to read again the transcript from the suppression hearing. Somebody needs to send that to me electronically. I've got it all somewhere, but I would like an electronic version of the suppression hearing so I can review that one more time. Okay, everybody clear on that? Okay. Now, what else do you have that we have to do, Mr. DeGuerin?
We have the Ake motion.
We have that, yes.
That's all that comes to my mind right at the moment.
Okay, well, I'm gonna recess. It's the noon hour. Y'all have to have time to work on this motion in limine so we can get an order entered on the motions, I guess. Another thing about exhibits, which we've kind of talked about off and on emails and such, when we've had a chance to talk about it. There are a lot of exhibits in this case. We have to somehow get them numbered, get them to Miss Hudson. She's going to be taking care of all these exhibits for us. They have a locked cabinet over in Henderson where it will all be safe, where it will only Miss Hudson and myself will have a key to the room. I know that you've brought all the exhibits with you. Is that correct?
Judge, we brought the exhibits that were introduced at the previous trial.
Okay.
That's obviously not all the exhibits we would seek to introduce, but we, pursuant to the email we received from the court for, we did bring those.
Okay. Then, on the break, I need for y'all to talk about what is going to be the master list of exhibits. The exhibits from the first trial have to be renumbered. So somebody's got to do that. And provide a master list that can be pre-admitted, subject, I'll ask you for objection, Mr. DeGuerin, of anything you object to from that previous trial that you don't want to have re-entered into this one.
Okay.
But we need that list. I think we're going to have two lists. The first list, the second list. The second list will be exhibits that were not admitted during the previous trial. What is that list and what does it look like? If it's these financial records or something else that you have that you anticipate that is going to be relevant, do you know right now what that might be, Ms. Tanner?
Your Honor, I've had this come up in other cases before that are either retrials of the same case or trials of a companion case. And my understanding has always been once the exhibits are released by the clerk to the state, back to the state, when they're state's exhibits, they're kind of ours, and we can do with them what we wish. And obviously within the parameters of what we can do with the exhibits. But in the past, what we've done is just simply renumber them and not worry about what the old exhibits are, if it's the same one or not, and just put a new exhibit sticker on it over top of the old one, because the old exhibits or the exhibits are retained in the court file, copies of them.
Right.
And so as far as making a list of the old stuff, that's, I think, all well documented. So I think it would make it a lot easier for everyone if we just provided the court reporter with our list of 1 through whatever, and not worry about what the old numbers were, because they're really, frankly, not relevant. Okay, thank you.
That's fine, unless there's an objection that you have.
No, in my understanding, you want to have some kind of list so we can compare them.
Well, I don't know that there's a need to compare them. I just thought it might be easier if we had the list from before and the new list. But if we're just going to have a running list of exhibits, that's fine.
Frankly, it's for the kind of case it was, there weren't that many exhibits introduced in the first trial. So I don't think it'll be too...
It's not cumbersome, then let's just do it that way. All I want is for there to be some effort to agree on what exhibits. If we have to have a lot of proffer of proving up, a lot of business records or something else that doesn't need to be proved up, you guys need to start agreeing. You don't have much time. And we can do this before April 1, or we can do it maybe we can't do that, because your opening statements to the jury are going to be talking about what evidence is going to be there. So you got to get this done. That's all I'm saying. It's got to get done. And I think you're already on notice of what those exhibits are going to be. Is there anything that you have not told them about that is going to be an exhibit in this case?
I mean, other than just saying, we're going to introduce these checks from this account, they have them all. I mean, I haven't given them my trial outline, but other than that, I mean, they know what all we
Okay.
have. There's nothing new that I don't think that's not within the discovery. Now, there is physical evidence, obviously, Your Honor,
Right.
that is in our custody, and that's in our evidence room, and that's, the evidence that we have asked them, whenever you want to come see it, you're more than welcome to. But no, I can't imagine there's anything that.
Can you bring, were you planning on turning everything over today? Or no?
I have.
You have?
I have I brought with us the exhibits that were introduced in the previous trial. Part of the problem is, and I don't want to get real far off in the weeds, but we've waited to start pulling the financial documents that we will use in the trial until very recently, because we wanted to give them an opportunity to see the financial documents in the same form that they were in. Recently, we finally were just like, we can't wait any longer because the court's going to kill us. And so we've started pulling the documents, so we're a little late in doing it compared to where we want to be, but we're working on it, and our legal assistant is frantically pulling them and getting them organized for us, and I obviously anticipate we'll have that done for April 1st.
Okay, well, let's do this. If you're all in Austin, except for Mr. DeGuerin, if you can get it organized, which I'm sure some part of your office, you're doing all this, at the point that you can let them see what especially on the financial records, what you're planning on admitting as exhibits so that they can see it, then let them do so, and maybe that'll get us a little further along here. But if we have to have a hearing on March 31st, we'll have to have a hearing on March 31st to talk about all this, and that means you're having to come up here a day early. But if I don't hear something good in the meantime that says we're working this out and we're working on it, because I haven't gotten a whole lot of feedback thus far, and I know that you have lots going on, you have other cases, but we have to get these exhibits put together. So be in touch, is what I'm saying.
And just for the record, Judge, to sort of expedite all of that, I should say that all of our business records are on file.
Okay.
And we've noticed the defense of all of
Right.
those. So that's a pretty good chunk of things, so for what it's worth.
Mr. DeGuerin?
On this same issue, I have what we call a will call list. I mean, they've given us, to their credit, they've given us a list of 100 witnesses or something like that early on. They're not going to call 100 witnesses. I don't want to prepare for 100 witnesses. I want to know who you're likely to call, so it narrows it down to like 30 or whatever it is. And I haven't had a chance to ask Ms. Tanner that in private, so I haven't asked it out loud.
Well, you'll have an opportunity in just a minute, because we're going to recess and you are going to talk about that, as well as motions eliminating, and go ahead and talk about the exhibits. If I give you 30 minutes to talk about it, then we could do your motion right before we reconvene. If you want to do that in chambers.
Okay.
Anything else? Do we have kind of a good game plan there? Take a 30-minute recess. Anything else? Okay, we'll recess for 30 minutes. Thank you.
All rise.
She must have took it. She may have put it in the.